Hi everyone, I'm going to do a 6-part series of a legal employer guide whereby I'm going to share 6 reasons why employers lose disciplinary cases in court. The first one being failing to provide evidence or disclose evidence you intend to use in the disciplinary process. Many employers will go ahead to do an investigation, have an investigation report, but they don't give this report to the employee. The law is very clear. The Court of Appeal has stated that it's mandatory to give an employer an investigation report that you intend to use in the disciplinary process, or any evidence. It doesn't have to be only the investigation report. If maybe it was stealing and there's a CCTV footage, if there were statements that were written by their colleagues, the other employees in regards to that issue, make sure you give them, and it's supposed to be timely, within reasonable time. And remember, a very important factor: the employee is not supposed to ask for the evidence. It's a mandate. It's mandatory for you to give the employee, whether the employee asks for it or not, you have to give the evidence. So most employers normally hold it, hiding behind confidentiality. Court has also been very clear. In the case of Akala versus KCB, court was clear that the investigation report must be given, and even though because there's a case where now the employer will state that the reason they did not give out the investigation report or the evidence is because they're trying to protect the whistleblower. Maybe the court has stated that you can still give out the investigation report, but you retract any information that will help you protect the whistleblower. So it's very important. You must provide all the evidence that you intend to use. Even in normal criminal cases, let's say you cannot be charged with, let's say, stealing, and then they don't give you the evidence they intend to use in finding you guilty. That's going against the Constitution. The court is trying to protect the constitutional right of the employee, apart even from their fair labor practice. Because the Constitution is clear, someone has to be given a fair hearing. And fair hearing cannot be done if you're not giving them the evidence that you intend to use. So this is very important for every employer. Ensure you make sure you provide all the evidence that you intend to use. Unless you're protecting the confidential, maybe it's confidential information. Ruth Tanui and Company Advocates normally assist employers in this process. We normally assist employers to establish clear protocols for investigation for any employee who's undergoing a disciplinary process. And then we also make sure we do the training for HR practitioners. And also we help you if there's issue of information you need to redact. We assist in ensuring that you only focus on information that protects the whistleblower. If you're interested in our services, you can book a consultation with us through the link in bio, or you can just contact us through the email on the screen.